Welcome, everyone. I'm glad you're here. If you've been with us before then, welcome back. Today, we're going to be talking about estate planning. Why are we talking about estate planning now? Well, after all, estate planning is nothing new. It's as old as the laws governing property ownership. We take these laws for granted, but they're essential. They protect your right to own specific property and not worry about someone else, either your neighbor or the government, from taking it away. When you have ownership rights, depending upon the property type, you can enjoy it for your use to sell it or give it away. So when you die, ownership will be transferred to another individual or entity according to the laws of succession. For example, a spouse or a child. Then that person will have full ownership rights. The laws of succession governing transfer of property at death are clear and specific, even though we may not always know what they are. For example, in some states, everything one spouse owns automatically goes to another. In other states, it's divided between the spouse and children. So, estate planning starts with knowing the laws in your state. Then you can decide if you want to take the laws into your own hands, so to speak, by drafting a will or a trust to name the people you want to receive the property after you die. But estate planning involves so much more than just wills and trusts. How you hold title to the property in the first place can have repercussions both while you're alive and after you die. What about your IRA? Most people just sign their IRA beneficiary designation forms without even considering it. These forms are powerful estate planning tools and need to correspond to the rest of your estate plan. Point is, the laws governing property ownership and property transfer are very complicated, and you need to know how they would affect you and your family if you died tomorrow. If you want to override these laws in some way, which most people do, to make things easier on your family, you must get proper legal documents drawn up. We call this getting your affairs in order, and everyone needs to do this. Now, what we cover in today's presentation is not legal advice, so please speak to an estate planning attorney for more details. Yes, life is unpredictable. If we've learned anything from the coronavirus, anything can happen to anyone at any time. Even in normal times, the news is full of stories about accidents and natural disasters and sudden illnesses. There are also many other events that can upend people's lives that you just never know. Death is unpredictable, indeed. And then there's the biggest mystery of all. The fact is, death is very predictable because none of us are going to get out of here alive. But the timing is usually unpredictable. And that's why we need to bring our affairs in order, so you'll be prepared when it occurs. Preparation makes life easier, in life and in death for everyone. Because the laws governing property ownership and property transfer are intangible, it's very easy to ignore them. But death is a legal event. So once a person dies, and these laws come into play, determining what will happen to your assets and possessions, that is, who the new legal owners will be. And if you have done your estate planning, you can live the rest of your life knowing that when your time comes, your loved ones will have the law on their side because you set it up that way. No estate plan. Because estate planning is so important, I'd like to spend a few minutes discussing what would happen if you had no estate plan. If you're unfamiliar with some of the laws that could affect you and your family, this could be a real wake-up call. No one to make healthcare decisions on your behalf. Let's say you got into a car accident or had a stroke and couldn't communicate with your medical personnel about your treatment options. Wouldn't you want someone to be able to make medical decisions on your behalf? That's what a healthcare proxy does. It allows you to name someone you know who cares about you to give instructions and permissions to medical personnel if you cannot. As an aside, this is a great document to have for children that are over the 18 as well. It's often the first part of estate planning because it's the easiest to implement. Your doctor may even have this form. So put this on your to-do list and get this done. No way to pay your bills or transact your business if you're incapacitated. While we're thinking about the possibility of becoming incapacitated, I promise you, once you have these documents signed, you won't have to think about them anymore. Let's also consider your financial or business dealings. Who would pay the bills? Who would transact business? If there's no power of attorney, no one would. Here's another thing that's easy to cross off your to-do list. Sign a power of attorney appointing someone you trust to manage your finances if you cannot do so. This is another great document to have for children that are over 18. At death, your loved ones may not know where to turn or what to do. Take a moment right now and think about what would happen if you died tomorrow. Would your family know what to do first? Would they know who to call? Would they know where your important papers are? What would happen to your pets that need care? What about your social media presence? Would they know what kind of funeral arrangements you want? Death of a loved one is a shock to the family, but you can make it easier on them by writing out letters of instructions. This does not need to be a legal document. Still, it's an essential part of estate planning because it expresses your wishes about the miscellaneous items and may even include expressions of love and gratitude. You could even make it a video. Your surviving spouse may not have access to funds right away. Lawmakers have designed the laws governing property ownership and property transfer to protect you. After your death, authorities will freeze your assets to prevent unauthorized individuals from taking them before completing the sorting process. Now, depending upon how your accounts are titled and what other estate planning measures you have put in place, this could mean the people closest to you cannot access assets until the law says they can. Worst case, your surviving spouse wouldn't even be able to get money out of an ATM. However, experts have determined if your money is in a joint account, it will be there to meet your surviving spouse's immediate cash needs. But what about their ongoing needs? Will your surviving spouse have enough assets to carry on and live comfortably? Will those assets be positioned to generate sufficient income for the rest of their lives? For married couples, estate planning needs to span 2 lives. Assets could go to the wrong people. Those laws of succession we've discussed will kick in and determine who gets your property after you die. What will happen if you don't intervene and effectively override these laws? Here's a chilling example. When Barry White died in 2003, he was separated but not yet divorced from his second wife. In the eyes of the law, he was still married, so his ex-wife got everything. Yet, his girlfriend and their children got nothing. Situations like this are why estate planning starts with basic legal knowledge. Who would get your property if you died tomorrow? Even if your situation isn't as dramatic as Barry White's, you may still want to finesse the distribution of your assets. Maybe you want some to go to the grandchildren. Perhaps you have a friend or non-family member who you'd like to leave some money. Perhaps you have some charities you want to continue support after your death. There are so many ways to design an estate plan that are nearly all improve upon the laws of succession as your state legislatures have written them. Taxes could eat away your estate. Now, the estate tax exemption is over 12 million. That's 24 million for couples. But people have gotten a little complacent about estate planning. That's true. If you died tomorrow and your assets totaled less than the exemption, there'd be no estate taxes. But there are 2 things to say about this. First, lawmakers have scheduled the exemption amounts to go back down to the 5 million and 10 million for couples in 2026. So if you continue procrastinating and Congress doesn't extend the current exemption amounts, your estate could be subject to estate taxes. The other thing is that estate taxes are not the only taxes to worry about. Some states impose their own estate taxes with lower exemption amounts. Some states even impose inheritance taxes on your heirs. Also, if you pass on an IRA, your beneficiaries may have to pay income taxes on the distributions. Now, these taxes usually can't be avoided, but they can be reduced or deferred if managed correctly. Your beneficiaries may be unprepared for new responsibilities. Another big part of estate planning is preparing your beneficiaries for their new responsibilities. Will they know how and when to take their RMDs from their inherited IRAs? How will they learn to manage this new pool of assets? Now, traditionally, people have conducted estate planning in secret. This is partly because no family wants to talk about death, but it was also because the patriarch and the matriarch didn't want to start family squabbles. Better that they deal with these things after they're gone, right? But today's modern form of estate planning is much more transparent. Parents want to help their children, and children often know how much their inheritance they can expect to receive, which means they're prepared for it. At the very least, you can introduce your kids to your financial advisor so we can start working together. Then, when the time comes, your children will have somewhere to turn and when they need help with things like RMDs and other items. Does your estate plan need updating? Okay. Let's say you already have your estate plan in place. You've seen a lawyer and had all the necessary documents drawn up, and it feels good. From my experience, I can attest that clients who have completed the estate planning process feel like a weight has been lifted from their shoulders. They know they have organized their affairs to ensure that their wishes will be fulfilled after they're gone. If this is you, congratulations. Now, I have to tell you, the job is never really completely done. Your estate plan will need updating as you move through life and your financial situation and family composition changes. We talked about the sad story of Barry White, whose ex-wife inherited his estate to the exclusion of his girlfriend and their children. There's also the story of Heath Ledger, whose 2-year-old daughter was left out of his will because he never updated it after she was born. Instead of everything, went to his parents and his 3 sisters. Now, this story has a happy ending because Heath Ledger's family gave all the money to Ledger's daughter. But not all families are so fair-minded. Also, sometimes people do their estate planning but fail to finish the job. Take, for example, Michael Jackson, who created a revocable living trust to transfer his wealth to his children and his mother after he passed. But he never funded the trust. Instead, he left his entire estate outside of the trust. The estate had to go through the probate process while Jackson's children and his mother lived off an allowance managed by the state's executor and a judge. Now, situations like this can occur for years. During the probate process, the estate faced numerous legal challenges, and creditors and Jackson's family fought over the proceeds. Let's look at some situations that may require updating your estate plan. You have more assets now. How much has your house appreciated since you last did your estate plan? How about your retirement accounts? Even if you're still under the federal estate tax exemption amount, an increase in assets could call for different strategies and tools and decisions about who gets what. You have fewer assets now. Maybe you have fewer assets than you once did due to portfolio withdrawals or investment losses. Reduced assets may call for different plans as well. Maybe you're not feeling so generous today. Perhaps that gifting program you set up just isn't is slightly more unaffordable today than it was at the time. Remember, estate planning is not just about transferring assets after your death. It's about ensuring lifetime income for yourself and your spouse. You may want to revisit your estate plan if your assets have risen or fallen in value. Your kids are older now. Children tend to do that. That minor child you provided for in your will may not be well past the age of majority. Those young children you once thought couldn't handle a large pool of assets may be all grown up and capable of handling an inheritance. Or maybe your adult children are in a place where they could use part of their inheritance now. If they need money for a house or a business, and if you can afford it, why not help them out? Lifetime distributions are a part of estate planning, and you get the satisfaction of seeing your money put to work by the people that you love. You have a new son and daughter-in-law. Has your family had weddings since the last time you updated your plan? Have you welcomed a new son or daughter-in-law into the family? This new union has special legal ramifications concerning your daughter or son's inheritance. Even if you have openly welcomed your new family member and are happy to share your wealth, your child's new marital status requires a fresh look at your estate plan. You have new grandchildren. The birth of a child is always a time that requires an estate plan update. Even if you've written your will or trust to include grandchildren not yet born, of course, to avoid unintentionally disinheriting them, you should update your documents to name the new child to make sure that all the necessary revisions are taken care of. You've gotten divorced or remarried. If you have recently divorced or remarried and haven't updated your estate plan, we'll excuse you while you go call your attorney. Truly, this is one of the biggest estate planning blunders. Keeping an ex-spouse as a beneficiary on a life insurance policy or retirement plan or even a will or a trust. People who have gone through divorce are usually so tired of dealing with attorneys, they put off updating their estate plan, figuring they'll take a little break and we'll get back to it later. Then they never get around to it. It's tragic. Or what if you have a new spouse? This new union brings its own legal consequences. If you have children of a former marriage, you'll want to balance everyone needs to ensure the estate planning documents reflect that. Now, we're not here to dictate how you should plan your estate. Those are complicated decisions. We're just here to remind you that failing to update your estate plan following certain legal events such as a divorce or marriage, could lead to disaster. You're thinking about divorcing or remarrying. Proactivity is what we like. If you haven't made the move yet but are thinking about divorcing your current spouse or remarrying a new one, please put your estate plan front and center. Remember, until you divorce, you are married in the eyes of the law. Now, it may be difficult or impossible to remove a soon-to-be ex from certain accounts while you're going through divorce, and because certain estate planning changes can complicate divorce proceedings, you need to consult with both your estate attorney and your divorce attorney on this one. Now, if you're thinking of remarrying, be advised to get a prenup. People have different opinions on these, so we'll just put it out there, and I'll let you decide, along with your lawyer, what is right for you. The tax laws have changed. Yes, they have. Tax laws may have undergone several changes since the creation of your estate plan. Now, unless you're a lawyer, you may not know which of these new laws might affect your estate plan. Most good lawyers actively stay in touch with their clients and notify them when changes in the law necessitate a review of their estate plan. Maybe your lawyer who did your estate plan hasn't kept in touch, or maybe you've moved to a new state where the attorney has not been admitted to the bar, or maybe they did try and keep in touch and you ignored those communications. Whatever. It's hard for ordinary people to keep up with tax law changes. Firstly, when new information is obtained in the news, confusion can arise regarding which laws have passed and which are still in the proposal stage. Among the past laws, it's sometimes unclear what the effective dates are, and some laws are so complex and arcane that an ordinary person simply can't understand their effect. For example, the laws governing all types of trusts are nearly impossible to understand without a deep understanding of how those trusts work for you in the first place. Now, one of those trusts could now be perfect for your situation, but you would never know it without an estate plan review. If it's been more than a couple years since you had your estate plan reviewed, it's probably time. Tax laws are going to change, and yes, they will. As politicians come and go, we can count on new legislation every so often to undo the last round of changes. Also, because many of our laws are due to sunset at a specific time, we know the laws are going to change. Now, we don't know if Congress will allow the laws to sunset, which means everything will go back to the way it was before, or if new laws and different legislation will be passed before the sunset occurs. All we know is laws in the future will be different. And estate planning attorneys have their work cut out for them trying to keep the documents to accommodate the changes in laws that they don't even know what the new laws are going to be. However, frequent reviews and revisions can help you stay on top. And remember, what matters is what the laws are in effect when you die, not when your documents were drafted. You've moved to a different state. Many laws governing estate planning are actually state laws. Now, Some estate planning documents can carry from one state to another, but some need to be drafted anew to comply with the new state requirements. And there might be some laws in the new state that point to a new strategy. Bottom line is this: if you've moved to a different state since you had your estate plan done, make an appointment with an attorney in your new home state for a thorough review of your estate plan. Now, your executor or successor trustee is no longer willing to be able to serve. Now, you won't be around to watch, but your executor or successor trustee will be very busy after you die, rounding up all your assets and accounting for everything, and eventually distributing them to your chosen beneficiaries. While you're alive, you'll want to keep tabs on these people, because presumably you've chosen someone close to you to whom you trust implicitly. It could be an adult child, a family member, or a trusted professional, preferably someone younger than you. You may also have named a successor executor or trustee if the first person is not available. You'll need to keep tabs on them as well. If you discover that the person or people that you name cannot administer your will or trust, you'll need to name someone else. You've changed your mind about where you want your assets to go. One of the reasons most people put off doing estate planning is because they can't precisely decide to whom they want to inherit their assets, and that's okay. These are hard decisions, but it's better to take a stab at it than to have no estate plan at all. Your will or your trust can always be revised to change with your changing state of mind. Now, if you've forgotten who you named as your beneficiaries, it's time for an estate plan review. Pull out those documents and read them. Is this still what you want? Pull out your documents and read what's there. Is this still what you want? Have you changed your mind about anything, especially regarding things that we've discussed, like new family members or a change in marital status? If so, it's time to update your plan. Preparedness is the antidote to fear. This is a famous quote that applies to so many areas of life. Some people fear death because they worry about what will become of their loved ones after they're gone. I assure you, your family will miss you, of course. But a solid estate plan, they won't have to wonder about your wishes and can ensure that they meet them. Your estate plan may be about stating your desires, but you're also doing it for them. Taking the time and the trouble to get your affairs in order is one of the most loving things you can do on this earth. Let's start with a free estate planning assessment. I hope this presentation has opened your eyes to some of the estate planning issues. I want to make an appointment with you to sit down and determine your needs. We have an estate planning assessment that's pretty simple and quick. And once we've gone through it, we can help to establish your requirements. We can create a plan for you to address the tasks that you need to complete, such as organizing your records, meeting with an estate planning attorney, whatever. Whether you're doing your estate planning the first time or have any questions about your existing plan, we'd love to help. Thank you all for joining us, and I hope you have a great day. Bye now.